going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. It is Wednesday. It's halfway through the week. And yeah, I'm going to tell you guys this. Court sucked today. It was so hard to find just even a usable clip today. Which is why I did have a clip in my back pocket, which is the first one we're watching. It's a follow-up. We watched his arraignment on his probation violation. I don't know, it was about a week and a half, 2 weeks ago. This is a Judge Washington case where the guy was accused of trying to cut his tether off because there was cut marks all over it. Well, his hearing happened, and we're gonna watch that. So it's an interesting one, especially if we saw the first one, part one. But that's all you really need to hear about part one was the guy said he didn't try to cut it off, and the officers like, well, there's clearly cut marks on this. Well, we're gonna hear from a bunch of witnesses today. So yeah, let's get into it. And then I've got one out of Texas where we just have some guys yelling at each other. It's a debt case. Somebody is suing someone else over a debt, and there's a lot of yelling. So let's go have some fun with that one. Before we get into it, Terry Barnes, thank you so much for the 9 months. I do appreciate it. Also, Rich. I see you in the chat. Now, Rich said yesterday that I missed a super chat, and I was like, no, I didn't. And I knew Rich super chatted earlier because I brought it up on screen, but I never actually thanked him. And in my head, I checked it off. And so, Rich, I do apologize. I did miss it. I actually went back to the video. I was like, oh, he's messing with me. So I went back and I watched the beginning of my live last night, and it's like, yeah, no, he's right. I didn't actually say thank you. So, Rich, I apologize and thank you. So now, every time you say I miss a super chat, I'm gonna have to believe you, which sucks because I don't like giving you that power. You're gonna abuse it. Anyways, let's get on with the video. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. Well, real quick. Miss Orchid Flips, thank you for the 9 months. I appreciate it. That's awesome. All right, now let's go.
Court will recall the Ozell Hyman matters, 25 FB 1036 and 25 FB 1007.
Tiffany Woods for the people.
Allison Muller here on behalf of Ozell Hyman. Ozell, can you go ahead and state your name again, please?
Ozell Hyman.
Thank you. All right. It appears that we're ready to start the hearing. Is that correct?
The people are ready, Judge.
Defense is ready as well, Your Honor.
All right, thank you. All right, you may begin the bond violation hearing, Ms. Woods, and you can call your first witness.
Thank you, Judge. The people call Chris Davis.
Thank you. Mr. Davis, please unmute your device and state your name.
Chris Davis.
Thank you. And do you swear or affirm that the testimony you're about to provide would be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. All right. Can you spell your name for the record, please?
First name's Chris, Chris. Last name Davis, Davis.
Thank you. Your witness, Ms. Woods.
Thank you, Judge. Mr. Davis, could you please state your name again for the record?
Chris Davis.
And where are you currently employed?
JSG Monitoring.
And what do you do at JSG Monitoring?
I am the operations supervisor.
Okay. And how long have you been the operations supervisor?
I've been in this position just a little over a year now.
And what do you do in that position?
I oversee a team of monitoring agents and work with different contracted positions.
So I'm going to take you back to March 23rd of 2025. What happened that day?
That morning, I received a phone call from our on-call agent saying that there was a client in Washtenaw that we needed to meet with because of a strap tamper on the device.
Okay. And What did you do? Did you meet with the client?
Yep, I contacted Mr. Hyman and scheduled a time to meet with him at the Community Corrections Building.
And are you referring to Ozell Hyman?
Yes,
Okay. Do you see Ozell Hyman on your Zoom up at the top?
I do.
Could you just describe the clothing he's wearing?
Looks like he has a green jail suit on.
Judge, may the record reflect that the witness has identified Mr. Hyman.
Any objection? Ms. Mueller, any objection?
I'm sorry, Your Honor. I didn't realize I muted myself. No objection. Thank you.
All right, thank you. The record shall reflect.
So, you met with Mr. Hyman at Community Corrections?
That is correct.
And what happened, when you first met with Mr. Hyman?
I inspected the device.
Did you notice anything? What did you notice about the device?
There was a cut on a strap.
And did you discuss the cut on the strap with Mr. Hyman?
I did.
And what did he tell you?
I asked him what happened to the device, and he stated that he did not know there was a cut on the device.
Did he tell you how he thought the device was damaged?
Please stop.
Judge Washington in her her court record, this happens a lot. She'll just yell stop.
Texting. I apologize, Your Honor. We're back up and running on the record.
All right, you may proceed.
Yeah, that's very normal for Judge Washington's courtroom. I don't know why. It just happens. But it's a good way to lose your flow for sure. Shishina, thank you so much for the 19 months. 19 months, that is awesome. Thank you. Almost to 2 years.
Thank you, Judge. Mr. Davis, did Mr. Hyman tell you how he believed that strap was damaged?
He stated that he did not realize or know that it was damaged, and that he suggested it may have been due to the cold weather.
Is it possible for the cold weather to damage a strap in that manner?
No, it is not.
Okay. And from your training and experience, what did it appear had happened to the strap?
The clean slice in the strap, in my experience, indicated a cut.
When you met with Mr. Hyman, did he tell you at any time that he cut that strap?
No,
Did he tell you at any time that someone else cut that strap?
no.
Okay. And so when a strap is cut like that, what do you do next?
In this instance, I replaced the device with a brand new functioning device.
Judge, I have no further questions.
Thank you. Your witness.
Thank you, Your Honor. So Mr. Davis, I just really have a few questions here for you. So I understand it's correct that on the morning of the 23rd, someone from your company contacted Mr. Hyman about the Tether alert. Is that correct?
Yes, I believe our on-call agent did try to make contact with Mr. Hyman.
Okay, and they made successful contact with him?
I am not unsure of that. I was not on call. I was just contacted to meet with him.
Okay, but he did come in the morning of the 23rd, there to corrections to have his tether replaced, correct?
Correct.
Okay, and he came there on his own accord. You're not aware that he was brought into corrections by anyone?
Correct.
Okay. And I know you said this, I just want to make sure I'm understanding. So when you asked him how was the tether damaged, his first response was, I do not know. Correct?
Yep.
Okay. And so when he mentioned the cold weather, it seemed your impression was that he was speculating how this could have been damaged, correct?
That is correct, yes.
No further questions. Thank you.
Any further questions from you, Ms. Woods?
No, Judge.
Thank you. You may be excused, sir. You're welcome to stay or leave. It's up to you.
Thank you.
Thank you. Any further witnesses on behalf of the people?
None from the people, Judge.
Your witnesses from the defense, Ms. Mullen.
Thanks, Your Honor. Your Honor, defense would call Shanta Hyman, who's here on Zoom. Ms. Hyman, if you could go ahead and state your full name, please.
Shanta Hyman.
All right. We're going to ask that Is there going to be a second witness?
Your Honor, there may be, I do likely plan on calling Mr. Eddie Hartman. He is there on the device with Ms. Hyman.
All right, I'm going to ask that he goes to a different room and come back after her testimony.
Mr. Hyman or Mr. Hartman, do you understand? Can you please go in a separate room and have the door closed, okay?
Yes, yes, I will.
Thank you so much.
All
Okay,
right,
he's left.
thank you. You may proceed.
Thank you, Your Honor. Ms. Hyman, can you explain your relationship to Ozell?
He's my
Did-
brother.
Did she spell her name?
Oh, I'm sorry. No. Ms. Hyman, can you spell your name?
S
for the
H
record?
SHAWNTA. Last name Hyman. That's A. I'm sorry about that. That's HIMON.
Thank you. Please raise your right hand to be sworn. Do you swear or affirm that you promise to tell the truth, the whole truth, and nothing but the truth under penalties of perjury, ma'am?
Yes.
All right, thank you. You may proceed.
Thank you, Your
Is that the video you were asking me to check out in Discord yesterday? I haven't watched it yet. I after the stream last night, I ate and then I crashed instantly, so I haven't watched it. But I will. I promise I'll check it out tonight. Well, I gotta do some work tonight. You know what? I'm gonna check it out tonight before I get to work. All right, there we go.
Honor. Ms. Hyman, can you explain your relationship to Ozell, please?
He is my brother.
And you are now familiar with the fact that Ozell does or did back in March have a GPS tether on his ankle. Is that correct?
Yes.
And before we proceed, if she cut a tether, that is a felony. So, ma'am, you understand that if you cut a tether, you could be charged with a felony in this particular case, and that anything you say today can and will be used against you,
Yes.
and that does she need counsel if she plans to if she cut this tether?
Your Honor, she did
No.
not cut the tether, and that will
All right.
not be her testimony today.
All right, thank you. Then you may
Thank you.
proceed.
Thank you. Ms. Hyman, can you, on the evening of March 22nd, was there another person in the home with Ozell and your dad, Eddie?
Yes.
Okay. And at some point, did that person indicate to you anything relating to the tether on Ozell's ankle?
I'd object to hearsay.
Your Honor, if my response would be, as far as I know, hearsay is allowed in a bond violation hearing, according to MRE 1101B3.
That is correct. You may proceed. It is allowed.
Thank you, Your Honor. Ms. Hyman, if you could go ahead and relay the information that you heard from this individual who was also in the home with your dad and Ozell.
My sister told me that she cut his tether because he wouldn't go to the store for her and he was asleep. She was trying to wake him up.
And how did she tell you this information? Was this an in-person conversation or?
It was in person.
Okay. Did your sister indicate after doing?
Hey Laura, what page on Discord did you send that to? I'm looking right now. I don't see a link that I haven't seen. So I don't know where you put it. So I just want to make sure I find it.
That she was fearful of what might happen.
Yes, after she did that, she was very fearful. She's very young. She just had a baby and she was scared to go to jail.
How old is she?
21.
Your Honor, I have no further questions for Ms. Hyman.
What day did she tell you this, ma'am?
She told me this maybe about a month ago.
You know
when
the
she was
exact
still in
date?
the home. I don't know the exact date because soon after she moved out.
What's your sister's name?
Ariana Hartman. And can I please correct the court? I was just told she's 22, not 21. I just want to make sure didn't
Okay.
have it right.
Who told you that?
My sister, she's over there.
She's there today?
No, not the same sister.
Oh, okay. Ms. Woods, your witness.
So your sister told you that she cut the tether. Is that's what you said, testified to today?
Yes,
And you love your brother?
yes,
You have a good relationship with your brother?
yes,
And you don't want to see your brother sitting in jail over this, is that correct?
yes.
I have no further questions.
Thank you. Any further questions, Ms. Mueller?
No, Your Honor.
All right. May this witness be excused.
Yes.
Thank you. You may be excused, ma'am. If you could swap rooms with your brother, your
My dad.
father, please.
Okay, thank you. That
Yes, hello?
Yes. Good afternoon, sir. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand.
Well, hello, everyone that's coming in from Biggin. I know Biggin can't do an official raid, but I do appreciate him sending people my way. So, Biggin, thank you very much. And just a quick recap of what we're watching. We're watching a Tether violation hearing where about a week and a half ago, this guy who's in jail was put in jail for a Tether violation because his Tether had a giant cut in the strap. So he's saying he didn't do it. And yeah, but I don't know how else to explain it. He had a giant cut in his strap. The defense is it wasn't him, it was the sister. So we're hearing from the family right now. They're throwing the sister under the bus. All right. That's pretty much it. That's all that really happened. So Biggin, thank you so much for sending people my way. I appreciate it.
Could you state and spell your name for the record, please, sir?
Yes, Eddie Hartman, EDDIEHARTMAN.
Thank you. Ms. Woods, we already know what his name is, so you don't have to ask him what his name is again.
Okay. Thank you, Your Honor. I can go ahead with questioning at this
Yes,
time.
you may. I'm sorry,
Thank
Ms.
you.
Hall.
Thank you. Mr. Hartman, can you explain your relationship to Ozell?
Yes, well, he's my son.
And I understand that in March of this year, specifically March 22nd and March 23rd, Ozell was living with you at that time.
Correct.
Yeah, I don't think he ever left. I think they said I think Dad's about to say he was living in the garage or something like that, but no, he never left. So when there was the tamper alert, they found him instantly. It's a GPS tether, and it wasn't completely cut off. So I believe it was at the home.
Okay. Was another one of your children also living with you in your home at that time or staying with you?
Yes, I have a few of my children living with me.
Okay. Was your daughter Ariana staying with you at that time?
Yes, she was.
At any point after March 22nd, did Ariana express anything to you related to the GPS tether on Ozell's leg?
No, not at that specific time. Can I illustrate my knowledge of the situation?
Absolutely, yeah.
Yeah. Well, I have a garage attached to my house, which I call it my man cave, where I have my friends over, and my son was he had come to my garage. Matter of fact, he fell asleep in my garage. It's my understanding that my daughter
Can you ask the
Ariana
person
was
in the
mad
back
at my.
to stop talking, please? Can you ask the person in the back to please stop talking? Is that the jail?
Right,
Okay.
Judge, it's a
All right.
jail.
Try it
You know
again.
how
I'm
bad
sorry,
that
sir. I
audio
thought that
is?
was your background noise. You can go
Okay.
ahead.
Yes, well, it's my son that my daughter and my son. He was in my daughter's bedroom, and she was mad at him for some reason. I'm not quite sure, but she didn't want him in her bedroom. He fell asleep in her bedroom, and it was an officer come. Matter of fact, I don't know if it was Washington now. No, it wasn't Washington County. It was Inkster police come and addressed my garage at the time that he had made it to my garage and he was sleeping in my garage, and they were saying it was something going on with his tether, and they said that they thought at that particular time they even said that his cutter is something going on with his tether, and I say, well, I invited them in. The officer come in and we looked at his tether and they didn't see nothing wrong with it, you know, and they told him that he is to come to I think the correction officer there, where he was next to the jail there, and to to come in there so they can observe what's going on with his tether, and that's what he did. My son had been very much in compliance with everything that was been asked of him, and when we found out later, when he well after the police left, he found it was the next day. The next day, my son, I asked him about it, and he said he didn't do anything to his tether, and I believe him. It's nothing that I saw him trying to do. They were saying he was trying to run away or escape or something, and was that further thing from my son's mind. Matter of fact, I've been with him all the time. I've been bringing him to the jailhouse for all of his court dates. And he's been compliant. Matter of fact, it's been a few times that he's been asked to go for me to take him so he could be tested for alcohol, surveillance. I took him that. He's been compliant for everything that they was
So
asking him to do.
Mr.
Later
Hyman, if I
on,
could just cut in for just a minute.
Mhm.
So I think you've given a good explanation leading up to the event. So then, like you said, he went into corrections, he had his tether replaced.
Yeah.
And so, and Ozell indicated to you was your testimony that he didn't know how it was cut. So at what point did you
I didn't
learn?
say that.
Sorry, Your Honor.
I did not hear him say that.
I thought he said that he was talking to Ozell and he didn't know how it was cut.
Oh yes, my son said that to me. I asked him. I asked my son. I said, "Do you know anything about this?" And he said, "No, he didn't know."
Know
And
anything about what, sir?
we
Know
did not
anything,
know at that
sir?
time what.
Sir,
Mr. Hartman,
sir.
just slow down. Just
No and no. Happy birthday, my friend. Happy birthday. That is awesome. Thank you for spending a little bit of your birthday with us. I appreciate that. That is okay. Again, I need to find a new word. I can't keep saying awesome 14 times in one sentence. Can't. Words are hard. I need some new ones. What can I use besides awesome? It is awesome that it's Nona's birthday, though. Happy birthday, my friend.
Know
You answered-
anything about what?
Beg your pardon?
You asked if he knew anything about what?
About his tether.
What
Was
about?
because when I took him, and when we come from the officer, when he came out, and he was shocked, and I was shocked. He said his tether was cut, and I said, "How tether cut?" I said, what's this? He said he didn't know what had happened. We found later when we got back that my daughter, she didn't tell me, and he said it must have been his sister. He told me, he said it must have been Ariana because she was mad at him for not leaving out of her bedroom. And he also said that she did some other things to him while he was asleep. My son was asleep in her bedroom. And he also burned his trousers that he had on, trying to wake him up. So she was
Mr. Hartman, who burned the trousers?
I thought trousers only burned when someone was lying. I thought that's how that worked. Someone's lighting someone's pants on fire. Ah, I don't know why. That's hilarious to me. It's dangerous. Don't go lighting people's pants on fire. Let them light their own pants on fire by lying. Anyways, AM Perfection, thank you so much for the super chat. I appreciate it. Jump kick backflips and addicted to court. Yep, that's how it works. Thank you. I appreciate it.
Say it again.
Who burned the trousers?
My daughter, Ariana.
Okay. And did Ariana, so I understand Ozell believed it to be her. Did Ariana ever tell
Yeah.
you directly that she had messed with his tether?
No, she did not. She never told me directly, but I asked her, did she do it? And she never said that she didn't. She never said that she didn't, but it
So
was my
she didn't, let me
understanding-
just understand that point. So she,
Please slow down until the question comes to you, okay?
Well, no, she never, my daughter never told me, but she, I asked her and she said that,
Fantastic point.
her son, she
That is
said
a
my son
fantastic-
wouldn't leave out her room and she was mad at him. And, I think it was
So-
something else that was going on with them. They was, back and forth and they was together earlier. And, then, later on, for whatever reason, they wasn't speaking to each other and back and forth. And my son believed that it must have been her that did that.
okay.
And later on, also later on that day, my daughter Shanta told me that Ariana told her that she did it, but she didn't.
Sir, you can't say that. That's double hearsay. We can have
Oh,
hearsay.
okay,
but double
okay,
hearsay.
but okay, well, I understand. Okay, well, but that's
Thank you,
that's
Mr.
my.
Hartman. Thank you for
Mhm.
explaining. I think I have no further questions for you at this time, okay?
Yes, okay.
Ms. Woods?
Yes, where's your daughter? You're Mr. Hartman, correct?
Yes.
Where's your daughter Ariana today?
Well, she's with her mother in Detroit.
Okay, why is she not testifying?
Well, I think that she's very scared. She's thinking that she's going to have to go to jail for what she did, and she's worried about her baby. She don't want to leave her baby, and
I would just say I don't know. I'm not the defense attorney. It's not up to me who testifies and who doesn't. What kind of question was that, prosecutor? I don't understand what you like. I just say I don't know. Just say I don't know.
I explained to her that she needs to be honest if she know anything to tell the truth. And rather than to admit something that she might have did. She went to her mother, and
How do you
she's
spell
there
your
now.
last name, sir?
Hartman,
How do you spell-
Hartman,
How do you spell Ariana's first name?
Arranna.
Spell it again.
Arranna.
Does she have a
Ariana.
middle name?
Marie.
I have no further questions.
Yes.
Thank you. So I have one question. When you asked her if she cut the tether, did you see any indications that would lead you to think she did?
Yes. Yes. She looked nervous and she looked angry. Like she's mad at him. Because I asked her, and I told her, say, if you had a problem with him being in your room, you should have come and let me know what if I would have helped. Otherwise I would have made him leave out of the room. I really think.
When you asked her, sir, did she, what was her, how long did it take her a while to respond, or did she have an initial response?
Rich, pantaloon arson. Oh, I love that phrase. Where were you when I was making this thumbnail? I would have loved to put pantaloon arson on a thumbnail. Maybe I still will. That's awesome.
What was her initial response?
Well, initial response was she never said that she did it. She just started telling me the things that he was doing to her. and
I see.
saying to her, yes, she never did, she was mad at him.
Mm.
She was angry at him.
Thank you. I have no further questions. Any questions from you, Ms. Mueller?
Nothing further. Thank you.
Ms. Wood,
No, Judge.
thank you. All right, you may be excused, sir. Any further witnesses, Ms. Mueller?
Your Honor, if I could, I don't mind saying this just here on the record, but Ozell, I don't think anything further is needed from your testimony. So if you feel comfortable, I think we should rest there. Is that okay? Your Honor, then nothing for,
He's muted.
okay. Ozell, can you just confirm audibly? I did see your head nod.
Yes, I'm okay to proceed.
To rest there without your testimony, is that correct?
Yes, that's correct.
Thank you. Arguments?
Judge, the defendant, there was a cut on his tether. He went to community corrections. He said he had no idea how it happened. He believed that the cold weather caused it. We heard testimony from his sister that's blaming it on another sister. Then we heard testimony from a father who says that she never admitted to him that she did it. And it's just all hearsay, Judge. I mean, where's the sister? I find it extremely hard to believe that while Mr. Hyman was sleeping, that his sister got a knife, got into his bed, lifted up the sheets, lifted up his pant leg, and got in there and started cutting his tether. And why did she stop? She didn't cut it all off. Mr. Hyman never woke up. He didn't even know. He's saying he had no idea. So what made her stop if she was so upset? She wanted him to go to the store to get her something from the store. And she's 22 years old. She can't go to the store herself. And why would she stop? Makes no sense. This whole entire story makes no sense. And the fact that this whole family is putting someone at that now I'm going to research into charging a felony for. It's a little bit concerning, all the testimony all around, Judge. Thank you.
Thank you. Ms. Mueller?
Your Honor, what I find to be more questionable is that Ozell would have this cutting, if the prosecution story is the correct one, and he had this attempt to cut his tether. Ozell came to corrections the very next morning. As soon as he was alerted, he had a new tether put directly on. In addition to that, when the warrant was issued, he called me frequently the whole time the bench warrant was in place, just advising. He was helping his dad at the time, so he didn't turn himself in directly, but he was planning the whole time to turn himself in, which he ultimately did. So for someone who was allegedly planning an escape attempt, he really didn't try very hard to flee from the court. Ozell has always maintained that he did not cut the tether. That's what we heard from Chris Davis. His first answer is, I have no idea how this cut was in place. When he was asked to speculate how it might have gotten there, he came up with the first answer that popped in his head. Maybe it was from the cold, it snapped. We have credible testimony today from Ms. Hyman, and I find it more credible that this does involve another sibling. They understand that there's some risk to Ariana by giving this testimony today, but I think for the family, it's important that the truth comes out. It sounds like for Shonda Hyman, that truth was told to her. That was her testimony today, is that her sister admitted to messing with the tether. While Ariana didn't say that directly to Mr. Hartman, and he doesn't have firsthand knowledge of her admission, we did hear that there was a fight. She was angry that night. We don't understand the full details. It sounds like she requested Ozell to go to a store. He didn't. He crashed and fell asleep in her room. She was upset. She's a young person. I think we heard testimony, 22 years old. She made a mistake. That was the testimony we hear today. And of the two versions, this aligns better with Ozell's actions than him cutting the tether. So for that reason, Your Honor, we do ask the court to find that he's not responsible for this bond violation based on the testimony that we presented today and based on Ozell's actions and behavior before the violation and after.
Thank you.
I agree with what she said. There was a tamper. He didn't try to escape. He got the new tether put on. This violation happened. He didn't really understand what happened. No, what is this story wild? Absolutely. Absolutely, and I don't know if anyone actually bought that story. Could it have happened? I guess. I don't know, but the fact that that story was so wild, and there was a part about pantaloon arson in that story was hilarious to me. But yeah, the facts are the facts. He didn't run. He was there when they came to investigate it. You know what? Let's just go on. This is about the part where I start spoiling things. I don't want to spoil anything.
The court obviously wasn't there and can't say what did or did not happen, and the burden of proof lies with the prosecution. It's not a reasonable doubt standard. It's probably is it clear and convincing? Either way, I'm not convinced at either level about what happened that day. I find it difficult to believe that a father would come in and throw one of his children under the bus unless it actually happened. He's very aware that his daughter may end up being charged with a felony. I'm sure he wouldn't want that if he suspected that she didn't do it. And I agree with the defense that Mr. Hyman's actions more align with him just not knowing how he ended up in that situation and saying something kind of stupid at the moment about what did happen. I'm sure he was in a panic mode when he found out that his tether was actually cut. And I don't know. I don't know what happened, and that's the problem. I don't have enough information to determine that he did actually do it. I find that the sister coming in to say that the other sister admitted cutting it to her is credible. Her demeanor appeared as if she was telling the truth about that. And as much as Mr. Hartman talks, I find it difficult that he could say so much and not get caught in some misstep along the way. He likes to talk a lot, apparently. So I'm gonna accept what they're saying as truth and find that Mr. Hyman did not try to, well, the prosecution hasn't proven that Mr. Hyman was the one who actually attempted to cut his tether under this particular scenario. And Mr. Hyman is very aware that I have a whole lot of concerns about this situation. I wouldn't be finding that unless I felt.
Why didn't the prosecutor bring pictures of the cut of the tether? I think that would have been important. You could have analyzed, the angle of the cut, how deep the cut was. Was this, I think that could have helped a lot in this story. I don't know.
That it was the position and the impression I was left with at this time. So I find that there was no bond violation with respect to the tether cut that could be proven.
Thank you.
No, the tether guy was there. The tether guy was there early. That was the first witness. He was only there. He only answered, I don't know, 5 questions. It was really quickly. Because, okay, so I'm just still thinking. Here's the thing. If someone else is cutting the tether, it's most likely going to be from the bottom up, right? If you're cutting it yourself, it's going to be from the top down. That is a very simple way to see who actually was trying to do this. Because if you're trying to cut someone else's tether off, you're not going to be, cutting from the top down. And if you're trying to cut it off yourself, you're not going to go from the bottom up. Oh, man. I think I just broke this case wide open.
So that leaves us with the complication that when Mr. Hyman was set to be interviewed on by the probation department, he decided that he didn't want to be interviewed and didn't speak with the probation agent and asked to have the remainder of his jail time served.
And Your Honor, if I can speak to that, Ozell and I had shortly before Agent Pappenhagen came to see him at the jail, him and I had a conversation, and I did advise him that I believed he was likely close to maxing out his time on the OWI if the court is willing to grant the time for that. According to adding up his time that he previously served plus the full time, I believe as of today, he has 65 days credit on his operating while intoxication. So I had just advised him that from my standpoint, it made sense to probably ask for the time instead of going on probation. So when Agent Pappenhagen came to see him, I think Ozell was confused. He thought by signing that he was somehow signing up for probation. Ozell did try to call me several times from the jail, I think right as Agent Pappenhagen was there. Agent Pappenhagen reached out to me as well. Unfortunately, I did not see these calls. I think that was on a Friday. I would think I was in a meeting. I missed the calls. I did go see Ozell later that day, and understandably, Agent Pappenhagen did not have time to see him after that point. So I just wanted to let the court know that that's what happened with the sentencing. But I do believe that our request is the same. We would be asking for the court to sentence him to the 93 days jail for the
Well, we're
operating.
on different pages about how much credit he's entitled to.
Okay.
All right, real quick. Let me catch up on the super chats. Gifted memberships. No super chats. Phil, thank you so much for the 5 gifted memberships. I appreciate it. Thank you so much, my friend. Welcome to the 5 new members. 5 more from Caroline. Thank you so much. 5 more. I'm repeating myself. Welcome to the 5 new members. Thank you, Caroline. Sovereign Citizen Encounters. I've never heard of you. Like your name, though. Just graduated pull-ups. Thank you so much, Hutch. I mean, I don't. Definitely not Hutch. Thank you so much. I appreciate it. And Sharky, 8 months. That is awesome. Thank you, Sharky. All right. We're almost done with this one.
It says in here 51 days.
51. Okay. Your Honor, I was counting from January 7th to the 17th, and then he served from February 11th to March 17th, and then the current 19 days that he served.
Okay, wait, can you slow down, please?
Yeah.
What is the January date? He wasn't arraigned on this until February 11th. So he can't get credit for time that he wasn't actually already arraigned on the case.
Okay, Your Honor, sorry. I apologize then. That was my mistake of not, that was when he was being held on the other matter. So I understand.
Does he want to do the 42 days still?
Your Honor, I would either ask to speak briefly with Ozell in a breakout room, or if the court would like, and he could complete his sentencing interview with probation. If the court would consider amending bond, he could do that out of probation, and then we could adjourn this to a later sentencing date after he's met with probation to see what he might prefer after meeting with Agent Pappenhagen.
Anything from prosecutor on what you'd like to see happen at this time?
Judge, I would like to see him placed on probation. He had a BAC of 225. He has an old OWI, so technically this is a second OWI for him. So I would like him to do the PSIR, see what their recommendation is. I think he needs some counseling and some help in that area.
Mr. Pappenhagen, would you be able to interview him between now and June 16th? He would be out of custody. I'm reinstating his bond on the other case.
There we go.
Yes, Your Honor, I'll be able to interview him.
I'm gonna put them both. So do you know what you want to do on the pretrial today, Ms. Mueller?
Yes, Your Honor, we'd like to set that for final settlement conference.
The next final settlement conference is not until August, as you are aware, correct? Final settlement conference will be August 28th, 2025 at 9:30 a.m. Jury selection September 5th, 2025 at 8:30 a.m. I'm sorry.
August 28th date is our normal Thursday. It's a normal Thursday docket, which would mean that our final settlement would be an 11 a.m. start time, not 9:30, unless you
Oh.
want me to move it to the August 29th, Friday, August 29th. At 9:30.
I think so.
Just to be safe.
Yeah.
Well,
So I'm sorry. August 29th, 2025 at 9:30 and September 5th, 2025 at 8:30 a.m. for the jury selection. Bond is reinstated on that case. We'll come back for sentencing on the operating while intoxicated matter.
We're such a great group of friends. I was thinking the same thing. It's like, oh, Hitchbot, absolutely. Let me know how it is. I'm excited. I like a good mead, unless you can't. If you can't explain to us why you can't, then we all understand how it went. But good luck. Hopefully, we hear from you. Dark humor. Let's go.
On June 16th, 2025 at 10 o'clock a.m. I think
Alright. I think it's time to fast forward this. Nothing really happens from here to the rest. They give him the tether back. Yeah, I'm just going to fast forward this. We don't need
Did you
to
post $100 bond on the OWI case at some point, Mr. Hyman?
Yes, ma'am.
Right. The bond of $100 is reinstated.
I know there's only about 30 seconds left, but this is just dragging on.
We'll see you back here first on June 16th, and then after that, sir, we won't see you back until August, unless something happens, which you should probably make sure it doesn't happen again, okay?
Yes, Your Honor. Thank you.
Thank you.
Thank you, Your Honor. So I'll give you a call later today, okay?
Okay. Excuse me. Am I getting another tether or no?
Yes, it will be reinstated with the tether.
Okay.
All right.
Okay.
Got to wear Teflon pants. Stay away from your sister. Hide every pair of scissors. The bond conditions, the add-ons for the bond conditions would be hilarious. Stay away from your sister. All the scissors need to be taken out of the house. Knives are fine though. If you have a lightsaber, use that to defend yourself against your sister. All right. Next one. Now, this one's just entertaining. We have an angry guy yelling. That's about it. He humble brags a lot. He likes to say how rich he is, essentially, in a bunch of different ways. He doesn't actually come out and say, "I've got money." He's not that guy. The guy, I run a very successful business. I have 300 employees. I'm well respected around the neighborhood or the community. This guy's not paying his bill. He needs to pay. That's pretty much what this one is. So let's go. Let's go. Am I caught up in super chats? I'm getting carried away. Yep, we're caught up. Let's go.
The last case on the docket is Texas Rock Solid Building Services LLC versus Perry Building and Design LLC, Sean Perry. I think everyone's on Zoom.
Sir, I'm here, Your Honor.
Yeah, I will say before we get into this clip, this clip is a result of a very slow court Wednesday. I can't tell you the last full day of court, meaning no holidays. Just about every court had a docket today. Everyone behaved themselves in court. Let's just say that. So there was very few clips that we could grab from court today. That's why not a lot of channels posted a lot. I'm pretty sure everyone noticed that. Well, you might not have, but I did. Okay, let's go.
You are?
I'm Andrew Dumar, president of Texas Rock Solid Building Services.
Okay. You're the
Your Honor, this is Billy Davis, counsel for the defendants, Perry Building and Design, and Sean Perry.
And what we have on this morning's docket is the defendant's motion for summary disposition. And of course, that's
Yes, sir.
that's unlike a motion for summary judgment, which would require a response.
I actually do think that sometimes. I think people go into court now, like in their head, like, I'm going to behave. Doesn't matter how upset I get or how frustrated I get. I'm going to behave. I don't want to end up on YouTube. I think that's starting to get around.
And 21 days, but since we're in JP court, it's a summary disposition and no response is required. And whoever is opposing the motion for summary disposition can just appear and argue. So the defendant, Perry Building and Design, this is your motion. Let's hear it.
Yes, Your Honor. Appreciate that. Can you hear me okay?
Yes, I hear you fine.
There's some storms here in Houston, so I was hoping that we didn't have any connectivity issues. So just by way of background, Perry Construction is a general contractor. This is a lawsuit regarding the construction of a project that is called the Take 5 Oil Change Project in San Antonio on Goliad Road. Perry Construction hired Texas Rock Solid Building Services to provide masonry work as a subcontractor. As of late January of this year, I believe, 2025, the plaintiff, Texas Rock Solid, was paid for its work on this project. And when it was paid for that work, it signed an unconditional waiver and release on final payment. That is included as Exhibit A to our motion for summary disposition. This is a statutory lien waiver, Your Honor. This is a form promulgated by the legislature that's used on construction projects and clearly states that if you haven't been paid, you should use a different form, but that wasn't used. The unconditional waiver and release was signed by Texas Rock Solid Building. And in the middle of the conditional release the unconditional waiver, it says that the party signing waives and releases a bunch of different rights, including lien rights and, importantly, any claim for payment.
I've never actually seen one. I've seen the commercials. The commercials are funny, but I've never actually seen one of the oil change. Every quick oil change is like a Jiffy Lube around here.
Okay, related to the work it performed in this project. So this was signed in January 27th of 2025. It's sworn to, signed by Texas Rock Solid, yet Texas Rock Solid initiated this claim, I believe, on February 7th of 2025, and is trying to seek damages arising and related to this project. Damages that it does not have a right to seek anymore because those claims have been released. It's a pretty straightforward issue, Judge. If the plaintiff wanted to carve out or preserve claims, it could have definitely modified this document. It could have written something on there, but it didn't do that. It released it. And so it does not have any right to be paid any money, and this claim should be dismissed. With respect to the exhibits that were filed, Judge, if the court has had an opportunity to look at those and the exhibits by the plaintiff in support of its, I assume, response here today, everything that was submitted predates that release. So all of these emails predate the January 27th, 2025 release that was signed. So I'm curious to hear what the other side has to say, but this is pretty clear. They've signed this release. They've given up their rights by a statutory form. and there's no basis for them to proceed in this case.
Okay,
We're asking the court to dismiss the claims.
okay, let me hear from the other side.
Your Honor, this project started, and the reason why we brought this up too is we have several jobs with Sean Perry. Sean Perry, and Perry Construction, we have other projects that we are in arbitration with them as well, not because of faulty work, because of failure to pay, because Sean Perry got paid and did not pay us. They have no problems, even with the Take 5. The only reason we got paid for that, we started the job on September 16th. The owner paid Perry Construction on October the 15th. October the 15th. It took Perry Construction. We had to file liens. We had to file arbitration, which he didn't end up going to. We had to do all this stuff. And it wasn't until we went to actual Take 5 itself that had to drive all of San Antonio that we got paid from Perry Construction. And it was from the owner. And one of the reasons why it's so important that we do not just let Perry Construction and Perry off of this stuff is because he is continually doing this to a bunch of different subcontractors / owners that now have liens filed on their buildings and that we're trying to get paid on. I mean, but that's a whole nother aspect of it. And the reason why we brought this claim up is when Sean paid, or when the contractor or the owner finally paid us for this project, and he paid us. Remember, we finished the job in September. We didn't get paid all the way until it was January 24th. So I mean, you're talking October, November, December, 4 months that Sean Perry was basically holding on money that he wasn't supposed to get hold. And the Texas quick payment law clearly states that he has to pay us within 7 days of receiving money. We know that he got paid on October 15th from the owners. And that's just this job. It's not even the other jobs. And the reason why I want to make sure that Sean Perry does this, because if we continue to let general contractors like Perry Construction take advantage of good contractors, subcontractors like me, we're going to continue having bad subcontractors or subcontractors that don't finish work or can't finish work because people like Sean Perry do not follow the law, do not pay on time, do not do it. And the reason why so what this money is about trying to get paid, Your Honor, is what Sean Perry told us. He goes, hey, listen, you release, help me release the lien, because that's how the owner would pay me. The owner would pay me if we release the lien. The only way that I could get paid, Your Honor, if I release that lien from the owner, because Sean Perry could not freaking pay me. So we released the lien. In doing so, Sean Perry, he said he was going to pay me for the arbitration fees that I had to pay, was like $5,600. When you go to arbitration, you have to pay those upfront fees. When I had to lien that job, it was another $1,800 to lien it to have.
Lone Wolf, I am so glad I'm not the only person that had that in my head. One of a kind. I don't know if anyone else gets the reference, but that's been in my head since I heard this afternoon.
Attorney lien it to make sure it was a proper lien. To release the lien, I had to pay another $1,200. So my computer doesn't die. I actually just flew into England today, so I don't have the converter yet. $1,800 just for that. I'm talking. And then we have the interest that should have been paid and everything else like that. So yeah, there was a lien release that was signed to help Take 5, because Take 5 said, hey, listen, we'll give you the money. We'll make sure you get paid if you release that lien. So
I mean, yeah. But it was basketball. Steve Perry. I know he's the lead singer of Journey, but there was the quote that Lone Wolf said is basketball. The way he said it, Steve Perry.
Once again, it was kind of like a gun to my head. What do I do? Sean Perry doesn't fulfill his responsibility. We've got to get paid. I have to pay people. I have employees. I have vendors that I have to pay on time, which they were paid on time. There was no liens that were ever filed on any of these jobs that Perry Construction still owes me today. And once again, Your Honor, we cannot let a general contractor get away. Like I said, it's not just this job. I have several jobs with Sean Perry that he did not pay me, not because of quality, not because of anything, The attorney didn't say, "Oh, we didn't pay Andrew because no, I do great work. I have over 300 employees. I'm a reputable subcontractor. And yes, we did something nice for that owner. And for his attorney, and these are the people that make it so hard and why the sub base is so terrible in our community is because people can't get paid on time. But and so the money that we're suing for is the money that it cost us to go to mediation.
I swear to God, if you guys rip on me 14 or 15 more times, I'm out of here. Wake up, Squeak! You're my new best friend. Really? Are we going to the zoo? Oh,
To
such a
file
good
the
movie.
lien, to take the lien off for the interest and all the other BS that you see that it took us to try to get paid when Perry got paid and didn't pay us. And it's a misdemeanor. It's a misdemeanor. And more than anything, Sean Perry someone needs to hold this guy accountable. Someone needs to hold Sean Perry accountable because not just me he's doing it to, he's doing it to a slew of people, and the owners are the ones that have to pay his bill. So I rest at that, Your Honor.
Okay. So you were paid in full by the owner?
Yes.
Okay. Timely? Because you said that the law
No,
says 7 days.
No, we didn't get paid until January. The job was started September 16th. We finished the job by September 30th. We're a very fast, efficient crew. We didn't get paid until January. We're supposed to get paid within 30 days of invoice, 7 days when Perry Construction gets paid. Perry Construction got paid on October 15th for my money. I find after emails, and then finally having to go down and visiting the Take 5 and basically saying, hey, I'm going to wait at your freaking Take 5 because they're already open. They're already doing the owner end up basically paying us. Yes.
Okay.
And then Sean Perry, he basically said he would pay me for these fees. And once again, his word is about as good as his contract. And like it says in the master service agreement, it says, whoever prevails, or if I have other fees, he's supposed to pay me for those problems.
Okay.
So he made me incur other fees is what I'm basically saying.
Mm-hmm. So I guess my question is, does this unconditional release affect the costs that you incurred doing the mediation and getting the lien and those types of costs?
Correct. That's what I'm saying.
Yeah.
All we did was release the lien for the building.
Yeah. Okay. Mr. Davis.
Yeah, respectfully, Your Honor, there's a conflation of what we're talking about here. This is not a lien release document. This is a statutory unconditional waiver and release. If there was a lien that was recorded against this property, there has to be a separate lien release that is filed and recorded to release that lien. None of that's before the court right now. And everything that Mr. Dummer talked about on this, what he testified to before you, Judge, was all these claims, all these issues he contends occurred.
Please tell me you got that insult. Everything that Mr. Dummer talked about, it's Dumar. Nice one, attorney.
Prior to his company signing this release, which clearly says the company is releasing any claims for payment. Okay, so I appreciate his arguments, but he signed a document that waives his rights. And so if he wanted to reserve those rights, if Texas Rock Solid wanted to reserve anything, they could absolutely reserve things in this document, but they didn't do that. They didn't do that, Judge. And that it's as kind of black and white as that. And I, there's a lot of things that were said that aren't necessarily before the court. We're not here talking about other projects. We're not here to talk about other issues, other subcontractors. The petition, as it's alleged, is not about trying to prove some point. It's about money that Texas Solid Rock contends it's owed as a result of the work it performed on this particular project in San Antonio. They were paid and they signed a release that eliminates any other obligation for payment. And it's a statutory release. Promulgated. It's this form, Judge, comes out of the property code, chapter 53 of the Texas Property Code. It is not something that we made up. It is a statutory release, and they signed it, and it eliminates their claims.
Okay. Mr. Drummer, response? Mr. Dumar? Bryce? I think we lost him. There you are.
He did announce to the court that he just arrived in Europe. Oh, I
Mr.
just
Dumar?
arrived in Europe. My computer.
Bryce Dumar?
Sorry, sir. Can you hear me now?
I could not hear you. You were muted.
Yes, sir. Can you hear me now?
You have a response to Mr. Davis's?
Yes, sir.
position?
Sorry, Andrew got dropped out. So I'll just keep going on this point that this isn't for the main contract that we're talking about with the release. This is the damages caused by after the project's gone, having to go through arbitration on this project, having to go and file all these things, and having to file all this, and then at our expense, we have.
Yeah, to quote Peeps, I'm you know what? I'm just gonna flat out steal Peeps jokes. We got Dumb and Dumber.
Had to do that, and then so this is pretty much just for damages, not off the main contract.
Okay, anything else? Gentlemen, either one of you.
Nothing from the defendant, Your Honor.
I'm sorry, what? Andrew's back on. Okay, Andrew is back on. Where is he? I'm being told Andrew is back on, but he's muted.
Oh, this is
Hey,
Judge
there,
Letterman.
muted.
This is Judge Letterman. He looks like the Latino version of David Letterman. So it's Judge Letterman, and I don't care what you say. I'm always gonna call him that.
And now I don't see him. We lost Andrew again.
Your Honor, Andrew will be entering Zoom again shortly.
I'm sorry.
He's trying to reconnect, Your Honor. Thank you.
Wait, I'm sorry. I didn't understand what you said.
Andrew is trying to reconnect or go back here in Zoom.
Okay.
He's trying to use his phone right now. I think there's a technical issues with his laptop. Thank
All right,
you.
we don't need to listen. We don't need to wait for this.
Sorry to interrupt, Your Honor. Andrew is asking permission to enter the meeting. Thank you.
Can you hear me, Mel?
Yes, I can hear you now.
Yes, sir. Better now.
Welcome back.
Now, I don't know if you heard Mr. Davis's statement, but I was looking for a response from you.
Okay, sorry about that. And sorry about that, Your Honor. I said I just literally flew into London this morning, and I didn't have one of those adapters for my laptop, and so you had a lot of cases today, and so it ran out of juice. So sorry about that. Was there a question, Your Honor, to me?
Yes, I was asking if you, I don't know if you heard Mr. Davis's last statement, and I was asking for a response to it.
I did. Can he repeat that, Your Honor?
Mr. Davis,
Yes, Your Honor.
made a statement. I don't know if you heard it. And I was asking for you to respond to it.
And if Mr. Davis can repeat that question, because I did not hear it, Your Honor.
Your Honor, would the court like me to restate my argument?
Yeah, yes. Well, I guess specifically.
Okay. Well, we
Yeah.
had a couple different, we have like 3 folks on from the other side. So, and what was the, okay. So I think and this was, I was responding to something that the other Mr. Dumar said in his time before the court, which was the contention that what's being sued for are items or liabilities that arise outside the contract. That's the argument that I understood was being said. In plaintiff's first amendment petition, paragraph 11, plaintiff clearly states that it is suing Sean Perry and Perry Construction, Perry Building and Design, for arbitration costs, interest, and damages due to breach of contract. These are not damages that arise outside of the contract for this particular project, the Take 5 oil change. The arbitration costs, I am completely unaware of any arbitration that has anything to do with this project. There is a separate arbitration that is going on between the parties related to a totally different project, not this project. And so the suggestion that these damages, including interest on contract amounts that are claimed to have been owed during the time frame that the plaintiff is claiming they're owed, all that ties back to the work they did pursuant to the contract. They're suing for it, and they have released those claims. All those claims arose prior to the release being signed. They've released them all. That's my argument.
Okay.
Well, and just to go back at him, or just to kind of combat that for one minute there, that lien release that we signed for that owner to get that lien done was only to help that owner. Once again, Your Honor, Sean Perry put Take 5, the owner, in a predicament that they had to deal with because Sean Perry did not pay us like he was supposed to. If he would have paid us like he was supposed to, one, he already breached his contract because in his contract it says paid when paid. Sean Perry was paid, did not pay. So he has no, once you breach, it's over. Everyone knows that. That's common sense 101 in law. Once you breach, it's done. So that lien waiver that we signed was for the owner, not for Sean Perry. The stuff that we're going about now is about Sean Perry of the extra cost that he cost us because he did not pay his bills. And I guarantee the shoe is on the other foot. That attorney would want to get paid for his time. This attorney would want to get paid for his lien. This attorney would want to get paid for him releasing this lien. This attorney would want to get all this other stuff. But now he's trying to use something that I had an agreement with the owner that I tried to do something nice because Sean Perry wouldn't do it. And he's trying to say, oh no, that's totally released the whole thing. Regardless, I might have released the lien, but did not release Sean Perry's right and per the civil code for the misdemeanor. There's a misdemeanor. It's it's laid out very simple. The quick payment law in Texas, it says that the developer has to pay the contractor within 35 days, and the contractor has 7 days to pay me. The developer did that. Sean Perry did not do that. Sean Perry's the only one that didn't do anything. Then cost me all this extra money. And yes, we did have to go through arbitration. And the reason why you came on late on the last one is because Sean Perry doesn't fucking care. Does not care about the rule of law. Does not care about the contracts that he signs. Because if he did, he would pay me right now for the jobs that he still hasn't paid me on.
All right, Mr. Humble Brag, I'm in Europe. Hey, I'm in Europe. I've got 300 employees. Where's your attorney? Thank you, Kat, for bringing that to our attention. Where's his attorney at?
So that's what I'm saying. Your Honor, He is trying to convolute something totally different. This is more of a thing that we're trying to do. One, I'm trying to hold Sean Perry responsible for the quick payment law. Something has to be done to this guy. He's doing this all over town. He's getting paid. He's not paying people. And then he's leaving the owners and developers left carrying the bag and having to pay people like us. And then I try to do a favor because I don't think it's right that that I have to wait 4 months to get paid when he got paid right away and he doesn't take care of his responsibilities. And then the owners have to do it. We need to get people out. We need to get GCs and attorneys that write these terrible contracts out of this freaking thing so that people want to come back into the sub trade work. That's all I'm saying. And that's why I don't think we should let him out of this particular deal.
Hey, here's the thing. He might be right. He might be 100% right. He's coming across as a jackass, though. He really is. I mean, you can tell he's angry. No idea what's going on with this case. Like I said, this was the best case I could find today, just because we have a guy yelling. That's it. I didn't do any background search. I don't know who this Sean Perry guy is. But yeah, we're gonna get a trial. Oops, I just spoiled it. Sorry, guys. Damn, sorry.
Okay. As you put it, this particular deal is specifically about, this case is specifically about this one contract.
Correct.
This one unconditional waiver and release.
Correct.
But the question that I had was what you sued for, the damages that were incurred for the cost of the arbitration, et cetera, for filing the lien. I'm not quite convinced that they fall under the unconditional waiver and release. Gentlemen,
Correct.
I think you're going to trial.
Thank you.
Okay? I'm going to
Thanks.
motion for summary disposition, and y'all can fight it out in a full-blown trial.
Thank you, Your Honor. I appreciate that.
You'll each be receiving a date and time for the trial, and come prepared to argue your case, both of you.
Fantastic. Thank you, sir.
Thanks, Judge.
Bye.
Sparkle Poots. Thank you so much for the super chat. One job, Colin. One job. I know. I ruined it. Well, that's it. That's it for the show, guys. All finished. That's all I got. I'm done. I don't care where you go. Can't stay here. I can actually force you guys to go somewhere. Where are we gonna go tonight? Who are we raiding? Oh, it's Wednesday. Who did we raid? We did KDZ last week. We'll do KFAR tonight. I remember, because I remember having the question. I remember asking the question. We went to KDZ. So we're raiding KFAR tonight. Make sure you go tell them I said hello. Thank you all for hanging out. Big in. Thank you for the unofficial raid. I do appreciate it. Thank you for the super chats. Give the membership milestone. You guys are all, hold on, fabulous. I didn't say awesome, but I feel like when I say fabulous, I got to say it, fabulous. All right. Go tell KFAR I said hi. I will see you all tomorrow. And until next time, bye.